Good day to all. We are here today because allegedly one of our UA Hospital employees disclosed protective health information, or PHI, of one of the hospital's patients. This was reportedly an impermissible disclosure of the patient's information. The employee, when handed the subpoena from the plaintiff, alleged that the UA Hospital employee did not follow the Health Insurance Probability and Accountability Act, or HIPAA, of 1996, where it states in Section 33 that the patient of the personal health information cannot be disclosed unless there is a judicial and/or administrative proceedings that are requesting the information through the court or administrative tribunal. With this act, a subpoena for the protected health information is deemed a valid disclosure if the circumstances follow the guidelines in Section 34 of the HIPAA Act, where the non-court subpoenas or disclosures can be given for one of the 6 reasons. First, as required by law. Second, to identify a suspect in a crime. Third, in response to a law enforcement officer's request. Fourth, to alert law enforcement of a person's death. Fifth, when the organization believes a crime has occurred, and in addition, the 6th, because the medical emergency did not happen on the premises. These major exceptions have a broad interpretation and therefore seen as a subpoena that is unsupported by court orders or as a reasonable and logical response to disclosure of the PHI. Since we do not know if the disclosure is because of the patient's civil suit or another patient's litigation, we cannot tell if the following added to the debate between the plaintiff and the defendant. Protective health information in the rules of civil procedure overrides the privacy regulations of HIPAA. If the PHI becomes public domain, the privacy is therefore not in question. The broad strokes of HIPAA laws leave many possible loopholes for those that choose to exploit them. In fact, under HIPAA, patients cannot prevent their information from disclosures by refusing to sign HIPAA forms or otherwise withhold their consent. The terms of HIPAA drafted in the company policies with the interpretation of those policies leaves open the possibilities for litigation. This paradox encourages the healthcare organization to spell out HIPAA guideline policies, therefore allowing the spirit of HIPAA guidelines to be with more substance. Confidentiality and privacy have a long history in medical conscience. Direction from the American governmental agencies to list and define the Patient's Bill of Rights and the HIPAA guidelines for PHI are the backbones for the healthcare organizations. With even a question of impropriety, UA Hospital re-examined the policies and procedures for PHI disclosures. This new policy at UA Hospital would set steps that follow the HIPAA guidelines to prove a subpoena's judicial and/or administrative validation. This validation will accompany documentation to the presenter of the subpoena on the determination of the subpoena's validity. UA Hospital established consequences for any employee that does not follow these policies on disclosures of PHI. These consequences can be from docking and pay to reporting to HIPAA regulators or up to dismissal. All UA Hospital employees have been scheduled for education on disclosures of PHI, and UA Hospitals continues to advocate for patients' rights. Thank you.